Hey all, Ann Kelleher, senior legal instructor with Blue to Gold, coming at you with the first monthly legal update. We went through the surveys. Thanks again for doing those surveys for us. Totally appreciate it. And this was the number one thing y'all asked for was updates, legal updates. So here we go. Now, the theme of this month, we are looking at circuit court cases from December of last year, so December 2021. The theme of this month's legal update is qualified immunity. But before we get into the QI cases, I want to touch upon some of the other legal issues, search and seizure issues that our circuit courts dealt with over the course of last month, the end of the year. So without further ado, let's get into the circuit court cases for last month, starting with the First Circuit. We had two cases from the First Circuit in December. The first one, State v. Miles, takes on my pet peeve, driving in the left passing lane. How many times have you been driving down the freeway, only to want to pass someone who is just hanging out in that left passing lane? So you have to do the unsafe thing and pass them unexpectedly on the right. Every single time I do that, I always wonder, where's the cop when I need one? Well, they're apparently in Maine, where Trooper Pappas sees Arthur Miles cruising in that left passing lane, just kind of doing his little thing. Waits until he passes the really big stay to the right sign before he flips on his lights and turns and pulls him over. Now, Trooper Pappas did have some other things going on, probably in his head, as he was observing and watching this car. First of all, he runs the plate. Plate comes back to a guy named Wilkerson on Dorchester Street in Massachusetts. Well, how many Wilkersons can there be on Dorchester Street in Massachusetts, where Trooper Pappas had a prior drug-related case? So he does have a subjective intent, right? This is a pretext stop. He's hoping to get some dope out of the car. But turns out the driver is not the registered owner. It's this Arthur Miles guy who happens to be in Maine on a suspended license with a probation violation and the party favors for whatever holiday party he's going to, the champagne and the marijuana. So marijuana, throw down dope. Now Pappas has PC to search a car, and I kid you not, surprise, surprise, he finds more drugs. So Miles challenges this stop, saying that this was a pretext and the officer's subjective intent should come into play. Now, starting with the state of Maine. The Supreme Court there in Maine in 1997, way back 1997, State v. Taylor makes it very clear. Observations of civil violations, including staying to the right, tag lights, tail lights, unreadable plate, even if it's just from a tail hitch that you can't see from certain angles, grounds for a traffic stop. So check that box. Similarly, First Circuit, bound by the SCOTUS's decision in Wren, right? Pretext stops are okay so long as the officer has probable cause and observed violation, reasonable suspicion that crime's afoot, or community caretaking. Boom, we have enough to justify that stop. So pretext stops, golden, First Circuit and in Maine. Next, also in the First Circuit, U.S. v. Guerero. First Circuit is asked to, next, also in the First Circuit, U.S. v. Guerero. First Circuit is asked to consider if an officer must tremble in their boots, have subjective fear. So again, it's another subjective intent case. If an officer must have a subjective fear to justify a protective sweep of a motor vehicle. So what happened in this case? Officers get a 911 call. Shots fired. Shortly after, we're talking just like a minute or two after that call for service comes out, officers in the area, they see Guerero just flying out of this area where the shots were fired, where the calls were coming in from. So temporal, geographic, and the flight, cops are like, boom, that's got to be our dude, at least by reasonable suspicion. So they try to make the stop. Guerero, however, does not want to stop for police. He continues driving, attempting to elude them until he is eventually stopped by police. Police remove Guerero from the car, do a pat frisk of him, and then do a sweep of the vehicle. late at night, dark and spooky, no one else around, no other vehicles in the area of the shots fired at the time the call comes in. Reasonable to believe that Guerero has immediate access to a weapon in the car. So, however, the First Circuit had a very unique rule that in order for police to justify a protective sweep of the vehicle, they had to have not only reasonable suspicion that the occupant was armed and dangerous and had immediate access to a weapon, but a subjective fear. And even where officers testified that they were fearful that Guerero had access to a weapon, because they did not appear fearful in their body cam video, the evidence that they discovered as a result, the ammunition in the car was suppressed. First Circuit changes course, right? So Rhode Island, the case where this came from, Rhode Island has never required the officer to have a specific subjective intent for fear. They follow the general rule that comes out of Michigan v. Long. Michigan v. Long, 1983, right? Long had TC'd, single vehicle crash, probably because he was drunk, but hey, little things. When officers get there and try to investigate this crash, Long has difficulty responding to their request. Hey, Mr. Long, do you have a license? A what? License. We need your license. Driver's license. Oh, then he goes and gets his driver's license out. Then they say, how about a registration? Huh? Registration, that thing that they get when you get your things. Oh, registration. He slowly works his way over to his car, and as he gets closer to it, they see a knife, the handle of a pretty good size hunting knife sticking out from underneath the seat, right? Reasonable belief that he is armed, check. Reasonable belief that he's dangerous. Dark, let's look at some of the facts here, specifics. Dark, spooky, lonely, a rural highway, single vehicle crash, one officer. He is drunk off his ass, so he lacks inhibition, and now he has immediate access to this hunting knife right under the seat of his car. Boom, check. Reasonable belief that he is also dangerous. Does he have immediate access to the knife? Yes, it's right under the driver's seat. So they frisk him, they sweep the car, they find marijuana, ding, ding, ding. Long goes to jail. So he challenges that. The Supreme Court says, we are going to balance out our privacy interests, right? What is Long's reasonable expectation of privacy to his vehicle under these circumstances, right? How reasonable it is for him to expect a significant amount of privacy in a vehicle that is TC'd on this lonely stretch of highway, a vehicle that's highly mobile, highly visible, highly regulated, coupled with the compelling government interest for officer safety. Given that traffic stops are inherently dangerous, and we add significant danger in this case under these other circumstances, it's like this balances out, right? We are going to allow officers to do the sweep based on this reasonable belief that armed and dangerous and immediate access to a weapon. So in Long, court says, yep, you get the frisk. So the First Circuit changes course here. They say, you know what? We have never required subjective intent in any of our other cases, right? We've never required it for probable cause. We've never required it for any additional reasonable suspicion. Why are we requiring it here? We don't know. So no longer do officers have to shake in their boots in order to do that protective sweep of the vehicle. So let's move into the heavy stuff, the qualified immunity. Now, before I get into the three specific qualified immunity cases heard by the circuit courts and with opinions issued last month, let's take a look at the state of qualified immunity from the top, SCOTUS. So in October of last year, October 18th to be specific, 2 qualified immunity cases came down from the Supreme Court. That really makes it very clear. Qualified immunity as a necessary legal defense to Title 42, Section 1983 cases is going nowhere fast. The only way qualified immunity is going to be eliminated is going to be at the legislative end. But at the court level, qualified immunity is not going anywhere fast. So let's just take a really quick look at the facts of the 2 cases and kind of the rule as the Supreme Court has kind of laid it out from these 2 cases. So our first case was Tahlequah v. Bond, where ex-wife calls police and says, hey, my estranged ex won't leave. He's here, he's drunk, he won't leave. So officers are hanging over a workbench. Now, one of the officers followed, the others close behind. No officer was ever within 6 feet of Rawls. The video is silent, but the officers say that they were telling him to stop, but he kept walking. Then, quote from the case. So this is the Supreme Court writing about their observations of this body-worn camera. It's a masterclass on use of force, right? He grabs a hammer from the back wall over the workbench and turned around to face the officers. Rawls grasps the handle of the hammer with both hands, as if preparing to swing a baseball bat, and pulled it up to shoulder level. The officers backed up, drawing their guns. At this point, the video is no longer silent, and officers can be heard yelling at Rawls to drop the hammer. He did not. Instead, Rawls took a few steps to his right, coming out from behind a piece of furniture so that he had an unobstructed path to Officer Gardner. He then raised the hammer higher back behind his head and took a stance as if he was about to throw the hammer or charge at the officers. In response, Officers Gardner and Vick fired their weapons, killing Rawls. Now, the 10th Circuit had a circuit rule that if officers recklessly escalated a situation, qualified immunity would not apply. And the 10th Circuit held that by taking the step toward Rawls, they recklessly accelerated that situation, right? That they escalated it recklessly, and therefore qualified immunity would not apply. The Supreme Court scolds the 10th, really. They really do. They scold the 10th Circuit and all the other circuits that are basically applying way too general a level of circumstances to deny qualified immunity. So what the Supreme Court tells us here is the rule. We have repeatedly told the courts not to define clearly established law at too high a level of generality. It's not enough that a rule be suggested by then existing precedent. The rule's contours must be so well defined that it is clear to a reasonable officer that his conduct was unlawful in the situation he confronted. Such specificity is especially important in the Fourth Amendment context, where it's sometimes difficult for an officer to determine how the relevant legal doctrine, here excessive force, will apply to the factual situation. Right? Neither the panel majority nor the respondent have identified a single precedent finding a Fourth Amendment violation under similar circumstances. Thus, the officers are entitled to qualified immunity. Therefore, while Graham v. Connor can start our analysis, that's how we determine if a force was in fact reasonable under the circumstances, this is not how qualified immunity is determined. The conduct in question must be addressed by the courts so that no reasonable officer would question whether their actions are outside the law. Okay, so, right, the concern is that the circuit courts are just applying taking too general approach, that force is excessive, boom, right? So I think what the court's really telling us here is we've got to look at the specific circumstances. Was the force clearly unconstitutional in this given set of circumstances, right? So the conduct has to, really the conduct is driven by the circumstances of the case. The other case that the Supreme Court published on that same day, Rivas-Villegas v. Cortesluna. This was reported in the exact same day, right? So, but this case is kind of on point to one of the cases we're going to talk about this afternoon, or today, or whenever you're watching that, right? So, where an officer placed the knee on Cortesluna's back while they were removing a knife from his pocket. Now, the Ninth Circuit in that case held that the officer dropped on Cortesluna so hard that it caused injury. Therefore, it was excessive and violated clearly established constitutional principles. However, the Supreme Court said, oh, dude, look at the circumstances here. Not only did Cortesluna pose a threat before officers even arrived, his estranged wife and 12-year-old daughter were barricaded in a back bedroom where, while the 12-year-old was on the phone with dispatchers, Cortesluna was running a chainsaw trying to get in the door, right? So he definitely has access to pretty significant weapons. When officers arrived, they could see Cortesluna through the window. He no longer had the chainsaw, but right? He did come out when challenged carrying a big frickin' machete. He did drop the machete when asked and then complied with officer's request to come out. Turns, he's got a knife in his left pocket, left rear pocket. So officers say, get down, get down, get down, knife, knife, knife. Officer goes in and drops, shin up against his arm, drops his knee down on his back, removes the knife. They get him into handcuffs and they immediately stand him up. So he is only on the ground, proned out with a knee on him for as long as it took to secure the knife, right? So very, very quick in time. So the Supreme Court looked at those circumstances and said, you know what? Here you have a guy who's posed a threat to his family, to the officers, and is still armed. It's reasonable under the circumstances to control that side of him to remove that knife. And so long as the officers did that reasonably, boom, we are fine. So SCOTUS reversed that decision, said the officers should get qualified immunity under those circumstances. So, right, so the court's really defining to the circuit courts how specific they have to look at the conduct of the officer and the circumstances to determine whether qualified immunity shall apply. So let's take a look at our cases. The three cases from December. First, Gordon v. Bierenga. Okay, so this was out of the Sixth Circuit, out of Michigan, in December. This came down. So what happened? Officer Bierenga did not clearly violate the Constitution when he shot and killed Gordon. So another officer involved shooting. Gordon was actively fleeing in a motor vehicle following multiple attempts by Bierenga to stop him for DUI investigation. So Gordon had actually eluded Bierenga at least once. Then Officer Bierenga finds him in the drive-through of a fast food restaurant, so tries to block him in. Gordon takes offense to being blocked in, slams into Bierenga's car, does a 24-point turn, crashing into other vehicles as well in order to elude the officer. Gets back out on the road, is driving excessive speeds, failing to yield, driving against traffic, putting everybody else on that roadway at risk, right? I take a 1,200-pound motor vehicle and I drive it recklessly down the streets at night. Yeah, there's a really good chance someone's going to be gravely injured or killed under those circumstances. So when the officer realized Gordon was just not going to stop and he was going to continue operating that motor vehicle, putting all motorists he came across at risk, Bierenga stopped him, shot him, killed him. Boom. Qualified immunity applied. Going to the 11th Circuit. This one doesn't go quite so well to the officers, right? Once you're in a holding cell, you probably shouldn't rush in and elbow the dude across the lips, even if he's being lippy, right? Being lippy is not a justification for active force. Just saying, right? So here, police arrested Johnson for selling cocaine to undercover officers. When he said he didn't want to go to jail, right, he became passively resistant. Get in the car. Nope, get in the car. Nope, get in the car. Finally, about 2 minutes of conversation later, Johnson gets himself in the car. Then they get to jail. Now Johnson doesn't want to get out of the car. This one only takes him about 30 seconds to convince him that getting out of the car would be in his best interest. So he complies. Now he's in the jail. He's in the holding cell area, and he doesn't want to go through the door. So jail staff put their hand on his shoulder, direct him into the holding cell, where he turns around. He's standing in the middle of the holding cell. Again, this is the record as reported by the 11th Circuit, right? So he is apparently standing in the middle of the holding cell when the officer with Miami Beach, Florida Police Department rushes in and boom, gives him a nice Muay Thai elbow across the lip, breaking his jaw and breaking some of his teeth. So the 11th Circuit there was like, no. What we have here is active force. And they say that under the circumstances, we have our circumstances here is this person is subdued and restrained. They are in the holding cell. The door is about to close. They're standing there complying with the request to remain in the middle of the holding cell when the officer rushes in with the elbow. So the clear rule established by the 11th here is any use of active force, such as strikes, blows, taser, OC shooting, etc. After a suspect is restrained and subdued is excessive and qualified immunity will be denied. So we have a clearly defined uses of force, active uses of force under circumstances where they are clearly subdued and restrained, now we know what the general rule is. We can't throw elbows once they're no longer resisting. So, right, so that's our 11th Circuit. And then finally, the last case I want to talk about today is out of the 5th Circuit Court of Appeals, Timpa v. Dillard. Now, as I talk about this, you're going to see part of the body cam video of this particular case. And so as you watch that, I want you thinking, does this seem to fit kind of that definition of clearly excessive force, or, right, would a reasonable officer under those circumstances have used force to this extent under these circumstances? So what are our circumstances here? So Timpa v. Dillard. So Timpa actually starts out the 911 extravaganza when he calls dispatch to report being scared. He admits that he is schizophrenic and off his meds and is running around in traffic, right? Shortly after he calls in, additional calls for service come in. Timpa has jumped on a bus. He is blocking traffic. He appears to be on something. Now, officers know this is going to be a kind of probably a mental health issue, right? This is probably a mental health, maybe a drug-influenced mental health, but this is basically a suicidal-ish kind of subject. So a CIT, other than, crisis intervention, even though this is not training. So the first officer en route calls for an ambulance. Once he gets there, Timpa has already been detained by 2 security guards in the area. He is handcuffed and on the grass, but he's not being controlled in any other way. So he rolls on his back, he starts kicking his feet, he tries to roll into the roadway where there's still traffic going back and forth, an active threat to himself and the officer. So the first officer on scene does roll him onto his stomach, prones him out. And from what I can tell on the body cam video, and again, correct me if you see something different here, really good use of restraint. He puts his shin up against the guy's upper arm. He's got his body weight over the guy. You don't see any of this like dropping of his knee down on his back. At least initially, you don't see his knee right on his back. He does kind of have his hands on his shoulders, but you see his hands kind of moving around back and forth. And Timpa's still able to kind of roll out from underneath this first officer's knee. So a second officer eventually comes in and restrains him on the other side. So now he's prone down on the ground. So EMT finally gets vitals, blood pressure, pulse, respiration, and doesn't seem to have any concerns about Timpa's status, right? He seems to be doing pretty well. And so that's about 8-9 minutes into this restraint. 10 minutes and 30 seconds, Timpa starts to cry, "Help me," over and over and over again. And 1 minute later, he stops moving. He just gets really quiet. You can actually kind of hear him. It almost sounds like he's snoring. And officers make a point of saying it sounds like he's snoring, right? So, which could be an indication of affected airway, something like that. But the issue that the officers are kind of thinking is he is simply fallen asleep, right? He was so aggressive and thrashing around so hard that he has just exhausted himself and he has fallen asleep. The EMT comes over with a sedative and also notes that Timpa seems to be, his status has changed significantly. And he asks, what happened? It's like, oh, he fell asleep. So he gets hit with the sedative. 14 minutes into this restraint, he's hit with the sedative and placed on the gurney and then moved into the ambulance. So the EMT, even though he sees the change of status, still hits him with the sedative and they load him into the ambulance, where they realize Timpa is not breathing. He doesn't have a pulse. Police assist with CPR, but they are not able to revive Timpa. So Timpa dies. Timpa dies. Now, the question here is when the Texas District Court looked at this, they said, you know what we have here are police using a very common restraint technique taught by every academy everywhere for a person who is an active threat against himself, right? Which does put officers in risk as well. So by thrashing around, continuing to thrash around, he continues to thrash around throughout, that the use of this particular knee supported prone restraint isn't something that the courts have been particularly concerned about up until August of 2016, which is when this incident occurred. The main concern of the courts had been hogtie, right? Once you also have their legs up, now you have them much more restrained, much more subdued, and in a position that does make it incredibly difficult to breathe. So that a continued hog-tie position is what the Texas court is saying is clearly defined as excessive force when someone is no longer actively resisting. But in this case, just the proned out knee, kind of knee in the back, isn't clearly defined as excessive force, right? As constitutionally excessive force. So they kick it, say qualified immunity applies. Challenge to the Fifth Circuit, and the Fifth Circuit focuses in on a very general rule. Any force at all after someone has been subdued and restrained is excessive, clearly excessive, and unconstitutional, and qualified immunity should not apply. 4 cases that they say prove their point, that show that this force was excessive. Only 2 of these cases, however, were decided prior to August 2016. In the first one, the use of force on a schizophrenic was the use of a taser. So schizophrenic who was actively resisting, so was tased, and then tased again and tased again, until he was down on the ground and simply trying to crawl away from the fact that he was being tased over and over and over again. A total of 35 times. Between being hit with probes, being drive stunned, he was tased 35 times as he was trying to crawl away. So no officer ever made an active attempt to actually get him subdued. So the court there said that that use of force was clearly shows this pattern of the type of conduct that is going to be clearly defined. So tasing someone 35 times, can't do that, right? Once they are no longer an active threat. The second one, so that was Carroll v. Ellington. That was a 2015 case. Bush v. Strain, this is a 2008 case. A woman is once again being whipped with the officer. She is in handcuffs, no longer actively resisting, when an officer comes up and grabs the back of her head and slams it into a car window, breaking her jaw. Again, the court there said, hey, this is force after they are subdued and restrained, therefore it is clear, it clearly establishes our rule. So we have tasing 35 times, slamming a woman's face into, actively slamming her face into a window, breaking her jaw, which was also charged as an intentional statutory violation, battery, as well as a constitutional one. So QI was denied there. Then our last 2 cases, Cooper v. Brown and Darden v. City of Fort Worth. Both of these cases were decided after Timpa, right? The first one was 5 months after Timpa, December of 2016, and the other one was 2018, 2 years after Timpa. So Cooper v. Brown, this is probably going to be the closest case on point, where our suspect hid from police after a DUI crash and was tracked with a patrol canine. Canine then bit this guy's leg. Once the dog bit the guy's leg, the guy started complying with all the officer's requests. He came out from his hiding place. He turned around, proned out, hands behind his back. He was secured. And even after he was secured in handcuffs, the dog's bite wasn't called off for another 2 minutes. You have 2 minutes of the dog bite after he was restrained and subdued. So two-minute dog bite was the court said was excessive. And then finally, Darden v. City of Fort Worth. Again, this was 2 years later. During the service of a no-knock warrant, Darden was tased twice, struck in the face and head and neck, and his head and neck were forcibly pressed on the floor in an effort to restrain and subdue him. So the court there held that Darden had been successfully restrained and subdued prior to being stuffed and forced and hit into the ground. Quick side note, those officers were acquitted in Darden. So clearly excessive force, I don't see it if they're getting acquitted for that. But anyway, apparently a jury did not see that as clearly excessive. So, right. So that was the fifth decision. And that was why they said any use of force, right? The rule in the fifth, any use of force after someone is subdued and restrained is clearly excessive and qualified immunity should not apply. So here's my question back to you guys and gals. What I want you to do, go down to the comment section and after watching the video, we'll put the link in for the full raw video of the body cam in Timpa. So you have an opportunity to watch the body cam video for yourself, see it from all the different angles, right? It's not the words, it's the action. So that's really what to focus in on. That clearly officers here belittled someone's health issues. So we need to be very careful about what we say on body camera. But again, it's not our words, it's our actions. Did our officers act in a way that was clearly unconstitutionally excessive? Right? So let me know what you think in the comment section. Anthony and I are also going to talk about this on the very first Blue to Gold podcast. So great news, huge news. We're wrapping up our legal updates. I want to let you know, hey, that our podcast is coming out next month. My very first guest is going to be Anthony Bandiero, our fearless leader here at Blue to Gold. We'll talk with him about, why he started Blue to Gold, kind of what his goal and mission for Blue to Gold is, talk about some of his favorite cases. We'll talk about this case, Timpa v. The Timpa case, and we'll take it from there. So we're going to be doing a podcast at least once a month, including legal updates once a month. Man, we've got so much exciting stuff coming up this year. Thank you all for your time, your effort. You guys be safe out there. I hope this was helpful and a benefit. If it was, hit that like button, hit that subscribe button, give me some comments. Let me know what you think, what more you want from us, from Blue to Gold, as you are. We want to, again, be that leader in your legal education to give you the tools you need to do your job to the best of your ability, because sometimes an offense is our best defense. All righty, fellas, gals, be safe out there, and I will see you next time.